First off, thank you for joining us this afternoon here at the Great Plains Mission Acceleration Center at Fire Point. We're on the campus of Wichita State University here on the Innovation campus. And thanks to you in the room, as well as those of you online for joining us for this event. Today is the first of our Innovate and Elevate series titled Protecting Intellectual Property. And this series is brought to you as part of the Defense Innovation On-Ramp Hub program that we are hosting for the National Security Innovation Network. The On-Ramp Hub serves an accessible open door to the DoD where companies and entrepreneurs can learn about how to enter the national security innovation base, discover how to access government programming and funding, and engage in national security events. So we're proud to be one of the 5 hosts nationally for the Defense Innovation On-Ramp Hubs, and we're located here in Wichita, Kansas. So we are excited to have our guest speaker today, Rob Gerlach. He is the Executive Director of Tech Transfer and Commercialization here at Wichita State University. And in this role, Rob has supported us and the team here at FirePoint for the last 5 years, working with U.S. Army Office of Research and Technology Applications at the Combat Capabilities Development Command Aviation and Missile Center in Huntsville, Alabama. And through this role, Rob and his team provide the science and technology community at AVMIC assistance with patent super disclosures, IP training, and a variety of other T2 activities. So this experience, along with Rob's background as a licensed patent attorney, uniquely qualified him to provide today's review of how he can be a bridge between academia, the private sector, and the government. So I'd like to welcome Rob Gerlach.
Awesome, thank you. You don't have to applaud. People in the room are applauding. Oh, okay. So thanks, Rob, for the introduction. That was Rob. I'm also Rob. It's a little confusing, I know, but we'll get through it. So like Rob said, I did go to law school. It's not typically how you start out at a party, at a dinner party. People typically try to avoid attorneys. So I don't like to lead with the fact that I went to law school, but I did go to law school, St. Louis University School of Law. I like to say the better law school in St. Louis, not Wash U. Sometimes that gets people offended if they went to Wash U. But so today, my goal here is, and I'll go through a lot of this, but my goal is for this to be a lively interaction. So if anybody has questions, feel free to raise their hand on the chat. Oh, I'm being told to move slightly this way. Oh, this way. Okay. So if anybody has any questions, feel free to raise your hand on the chat. We have people in the room that are monitoring the chat and all that stuff. So we'll call on people and have them ask questions to make sure it's interactive and useful for everyone in here. The purpose of the talk is to understand the intellectual property game. And so really that's what we're going to go through throughout this process. You know, I will be honest, this is the first time I've given this particular deck. We did try to put a little bit more of a DoD focus on it and all that. So bear with me as we go through this, but I think it'll be good. They always say when you start out a talk, you're supposed to draw people in with these exciting stories and everything like that. But when you went to law school, like I did, you also learned that you start out with all these boring disclaimers. So I'm going to get all these boring disclaimers out of the way real quick, and then we'll jump into the real stuff. So number one, I did go to law school, but I'm not your attorney. In fact, I'm not the attorney for the university either. I sit outside of the Office of General Counsel at Wichita State. I just like to provide people information on intellectual property, general knowledge on intellectual property, but I want to make sure everyone's very clear. I am not your personal attorney. I'm not your small business's attorney. I'm just a dude up here speaking about intellectual property, which kind of goes into my second disclaimer. Everything I'm about to say today is my own personal opinion. I'll be honest, I'm going to put my own flavor on a lot of things. Be forthright. It's not legal advice. Do not take this as legal advice. This is just general information for everyone to be able to understand intellectual property a little bit better and to know how to play the intellectual property game You know, you'll hear me keep talking about the IP game because I really believe intellectual property is a game and that we should all understand that as we go through it, to make sure we're getting out of intellectual property what we need for our small business. And lastly, my third disclaimer, I am an IP nerd. I nerd out on this stuff. It can be a little embarrassing at times. Like when I go into Walmart, I legitimately am looking at products and then pulling up the patents and assessing the patents and figuring out the quality of the attorney that wrote it. And is the claim set a good claim set or not a good claim set? So if you also happen to do that, if anyone out in the audience happens to do that, you would also qualify as an IP nerd. Another great example of being an IP nerd, I was at Silver Dollar City in Branson, Missouri, not too long ago. And I was getting ready to go on a roller coaster called Powder Keg with my son. It was the first time he was like riding the big roller coaster, so he was all excited. And I noticed that the Powder Keg had a circle R after it, indicating to me that it was trademarked. So I immediately had to pull out my phone, pull up the trademark database, pull up this particular trademark, see what attorney did it, what attorney convinced Silver Dollar City to file this trademark, because they don't trademark all of their roller coasters. This one just happened to be trademarked. So if you do that as well, you're also probably an IP nerd. So those are some things I'll throw out at the start here as disclaimers, and then we can kind of move into the real fun stuff. So goals. What are we trying to do during this talk? It's important to understand, one, that your small business has intellectual property. Every small business that has any type of engineering or products or services, which is basically every small business, has some form of intellectual property. A lot of times you'll hear a small business say, oh, I don't have any patents, therefore I don't have any intellectual property. That's definitely not true. Every small business has intellectual property. You may choose not to protect it. It may make sense not to protect it, but I promise you every small business has some form of intellectual property. And as I hope by the time we get through this whole thing today, that you will recognize that your small business definitely has some level of intellectual property. Number two, this slide, I should have balanced it better. But anyway, number two, understand that IP is a means to an end. It is not an end unto itself. And what do I mean by that? What I mean is don't get obsessed with getting intellectual property. I have a patent. I have a trademark. Frankly, who cares? The question is, how does that help you and your small business get to an end of what you're trying to do? So if you're trying to ensure competitors don't come out and be able to compete with you, understand how the intellectual property gets there. If you're trying to play the games because you're getting some investors and you want them to think you're really innovative, so you want to have a lot of pending patent applications and issued patents, because that's the way we measure innovation in the United States. Whether that's right or wrong, I don't know, but that's the way we do it. So if that's the game, then use your IP as a means to an end. But certainly don't lose sight that intellectual property for the sake of intellectual property is just silly. The only people who like that are the attorneys, because the attorneys get paid to help you prosecute your intellectual property, but you don't get anything out of it. So it's really important to make sure that you get something out of your intellectual property for your small business. And lastly, my third goal is hopefully by the time we're done, everyone who's listening and in the room will understand the difference between the different types of intellectual property. Nothing drives me more nuts personally than when I hear someone refer to a patent as a copyright or a copyright as a trademark. So I hope that we can help dispel those terminology and kind of get some of that down, so we all are on the same page as we're talking. You want me to? Yes. Okay. Awesome. So with that, we'll kind of dive into this with this first question of what is intellectual property? So intellectual property, in order for you to understand how your small business has intellectual property and what your IP strategy is, you must first understand this core question of what is intellectual property. And to me, in order to really be able to answer that question, we got to zoom out a little bit more and understand that in the world, there are two types of property. There's something called tangible property, and there's something called intangible property. And understanding this distinction is very important to understanding intellectual property. So tangible property is, it has a physical presence, it can be moved, you can feel it, you can touch it, you can smell it, you can lick it, you can do whatever you want to it. It is tangible property. This podium, clearly I can touch it, it's tangible property. Intangible property is a little bit unique. It doesn't have a physical presence. It's more amorphous. It's harder to wrap your arms around. It's in a lot of ways, it's kind of like love. It's hard to really understand what love is, but when you love someone, you kind of get that understanding of it. But if you were to ask to like be able to write it out and define it and clearly put the edges and parameters around it, that's kind of difficult to do. It's because it's intangible. So two different things. Now, one important thing to realize is that when I possess tangible property, let's say this clicker, this mouse thing here that I have in my hand, when I possess it, by definition, that means nobody else that's in the room can also possess it because it's in my possession. Tangible property. I have it, you don't have it. Intangible property is different. We can all possess intangible property. So what we've done is because I could write a manuscript and then people can replicate that manuscript because we have printers now. People can replicate that manuscript really easily. And so more and more people can get access to it, but their access to it doesn't deprive me from my access to it. So what we've decided in the United States and in most countries is that we want to help set up laws or regimes to encourage folks how to protect intellectual property because creating it takes a lot of effort and work. So why does intellectual property? Well, first, what is intellectual property? It is intangible property. So it falls into that more difficult bucket to understand from the first place. So already we're in a little bit more of a nebulous space, amorphous space, and I think this is why there's a lot of confusion around intellectual property from the get-go. So why it matters is that we want to protect our creative thinking and prevent it from being improperly stolen. This is how we as a nation continue to progress forward with our technology. This is why the United States has historically always progressed forward at a much more rapid rate than other countries, is because of the way we've set up our intellectual property laws. We want to incentivize people to push the boundaries, to create new things, to create products, and to generally make our lives better with these new products. So at the end of the day, we do that through these intellectual property regimes. So I don't know why I do this, but to me, I think of intellectual property as the four horsemen. It came to me in a vision one night, I guess. So there's the four horsemen, right? And so there's four main types of intellectual property. There's patents, there's copyrights, there's trademarks, and then there's trade secrets, which I will lump together as proprietary information, data rights, etc., all kind of can fall in that last bucket. So again, patents, copyrights, trademarks, and trade secrets. Patents and copyrights are constitutionally protected. Article 1, Section 8, Clause 8 of the United States Constitution is what enables the federal government to set up the rules around patents and copyrights. Noticeably, Article 1, Section 8, Clause 8 of the Constitution does not give the federal government any ability to regulate trademarks and trade secrets. That comes in through the Commerce Clause, which basically says if there's commerce between the states, then we as the federal government, because it affects multiple states, we as the federal government have the ability to regulate that. And that's where the trademarks come in and that's where trade secrets come in. But because of that also, every state in the United States has their own separate trademark laws that are state-based and their own trade secret laws that are also state-based. So a lot of states adopted the Uniform Trade Secret Act, and then the federal government came over at some point. It was during President Obama's era, I believe, is when the DTSA, the Defend Trade Secret Act, which is a federal regulation, came out on trade secrets. Anyway, more information than we need to get into here. So four horsemen, patents, copyrights, trademarks, trade secrets. It's always important to realize that there's this additional little pony. Again, I don't know why this is how it works in my head, but it does. And that pony is contracts. So realize that contracts can alter the natural regimes by the contractual language you insert into a contract. So contracts are very, very important. They can govern who owns what intellectual property. They can govern licenses back to other entities. They can govern whether it has to be assigned. All of that will be governed by your contracts clauses. So contracts are extremely important when it comes to intellectual property because almost all contracts will include clauses dedicated specifically to IP. So let's quickly, real high level, walk through each one of these regimes. The goal out of this is not for anyone to become an expert in intellectual property. It's for you as a small business to be able to start to understand what type of intellectual property I have and how I can build an IP strategy. But it is certainly not for you to have gone to law school. So we are going to go through this rather quickly. I definitely don't expect everyone to pick up on every single thing I'm about to flip through. But patents. So patents at a very high level cover inventions. Now, inventions is a defined term. We'll talk about that later, what it takes to be an invention. But if you're inventing something new, take it like an eVTOL or a new car, an electric vehicle, a new solar panel, a new method of manufacturing something, all of those will likely fall underneath a new chemical composition, a new vaccine. All of that's going to fall underneath this regime of patents. Then you have something else called copyrights. Copyrights is anything fixed in a tangible medium of expression for which you are the original author. So it's an original work of authorship fixed in a tangible medium of expression. An example of that would be if you, an example of a copyright would be if you're, Van Gogh and you're painting something, the second you start to fix it on the canvas by painting it, you are getting copyright rights in that. So copyrights are more artistic works. It can also be source code, can also be copyright protected. With software, there's a lot of oddities around that. But I will definitely say that it can also be copyright protected through source code. Then we have trademarks. Trademarks are anything that acts as a source identifier. So if it's like the Lululemon logo, Nike, Just Do It, anything like that, Coke, when you hear it, when you see it, you immediately know the identity of the source. So you as a consumer know what to expect with it because of the name associated with it. That would be trademark law. And then trade secret or proprietary information is anything that your small business can glean value from by keeping it protected and safe and not freely putting it out on the internet, for example. So tech spec packages, if you are manufacturing a new product and you have all your technical specifications around the molding and how long the mold opens and closes and how it should be drafted and all these things associated with molds, that would be fall in your tech spec package and would be trade secret. Unless, obviously, if you go and put that on the internet for anybody to see and download, it's no longer trade secret protected because you freely put it out there. You haven't maintained it and kept it confidential. So this chart here is just meant to lay it all out in a more comprehensive manner as an overview of the different types of intellectual property. Again, we'll dive into each one of these here in a bit, but this gives you an idea. It's important to understand, though. Now, I am very proud of this slide because I put it together and I came up with it on my own in my head. And I've actually modified it like 2 or 3 times. So what looks like a very simplistic and stupid slide, I find brilliant. Because I used to have trade secrets only off of patents and no overlap with copyrights, but I now firmly believe that you can have a trade secret that you obviously have copyright protection in because you fixed it in something, a tangible medium of expression, but yet keep it as a trade secret. So the purpose, though, without getting on my tangent too much, the purpose of the Venn diagram slide here is to intentionally show that a whole bunch of stuff overlaps. So intellectual property is intangible property, which makes it a little more confusing in the first place. And then to add to that confusion, we have 4 different areas of IP law that all can overlap in very unique ways. That is something that is often overlooked when you go to attorneys at times, because if you go to someone who's or practices primarily only in patent law and never thinks about trademarks and never thinks about copyrights or trade secrets, then they're obviously going to be more incentivized to focus on the green circle. But that could be to the detriment of your small business because it may make sense to build a strategy that pulls into some trademark things and trade secrets. So it is important to realize that you as a small business owner, you want to leverage all of them for my company And again, the purpose of intellectual property is to be another another tool in the toolbox of how you're trying to get to your desired end objective. So I'm now going to go through each one of these individually. Definitely, if anyone has questions, feel free to ask, or online, feel free to put them in the chat, and we can go through those individually. But patents, we start with patents. Why do we start with patents? Because patents are the area that I primarily focused on when I was in private practice. So I like to start with patent law. Again, constitutionally protected. So when I earlier said patents cover inventions, and inventions is a defined term, I said that because in order for something to be an invention, it technically has to hit these three requirements. It has to be novel, it has to be non-obvious, and it has to be useful. So novel just means it's never been done in that way before. If every car in the world's a white car and you're the first person to think of painting one car red, then the red car would by definition be novel because you're the first person in the world to ever paint it red, therefore making it novel. The question is, was it obvious to paint it red? I like to say obviousness is a question best left for attorneys to argue with in front of the USPTO. So the standard of obviousness is based on a person of ordinary skill in the art. So if I had a lot of white cars for 50, 60, 70 years, and then finally 80 years later, I decided to paint one red, you have some strong evidence that a person of ordinary skill in the art would not have thought to paint it red because of how long they had all been white. So that would be a way you would argue that it's not obvious. Then the examiner at the USPTO would come back to you and say, no, it is obvious because we have all different colors of books and book covers, and a person of ordinary skill in the art, that's hard to say really fast, a person of ordinary skill in the art would have understood to look to an adjacent industry potentially and recognize that different colors could be used. So it goes back and forth, but that's non-obviousness. The last one is useful. Basically, case law, the way it's all developed out, everything can be deemed useful. In essence, I promise you, if your small business is building a widget or something like that, or running a service that somebody like the government wants to purchase, it's going to meet the criteria for usefulness. Patents are a negative right, which means they only give you the right to exclude others from doing actions. So from making, using, selling, offering to sell, importing the invention, they don't actually give you a positive right. And this is something that often confuses people. I hear all the time someone will say, I've got a patent on it, therefore I can do this. Definitely not the case necessarily. You have a patent on it so you can prevent others from doing what your patent is on, but it doesn't mean that you yourself can practice the patented technology, because you may infringe someone else's patent rights by practicing it. And this is why we call it the thicket of patents, because just because I have a patent on it doesn't mean I necessarily can do it, because I may step into someone else's territory. That's a pretty nuanced thing. Definitely, if anyone has questions, we can go through that longer in more detail in a bit. You will never trip, stumble, and fall into a patent. It's expensive. You have to go see a patent attorney. You don't have to. I would highly recommend, if you're pursuing a patent, you would go see a patent attorney. Application costs can run anywhere from $5,000 to $15,000 to apply for the patent. That depends on the technology, obviously. Then you do go through this phase called prosecution. Prosecution is when your attorney will go back and forth with the examiner at the USPTO, argue about whether or not it should be issued. If they say, yes, it should be issued, that whole process of going back and forth is prosecution. It's probably going to run you, most people say rule of thumb, 2x what your original filing cost was. So it cost you $15,000 to file. It's going to cost me about $30,000 to prosecute. Now we're potentially up to like $40,000 to $45,000. Then, of course, once it gets issued, the government's going to want an issue fee, and then you got to pay maintenance fees at 4, 8, and 12. My point being is you will never trip and stumble into a patent because your bank account will tell you that you are pursuing a patent. So realize that it is an expensive proposition, and this is why it shouldn't be done lightly. This is why you should really figure out, does my small business need a patent right now? That's where the strategy part comes into play. If you only have $50,000 in the bank, does it really make sense for you to go spend all of that money on intellectual property? The answer may be yes, but the answer may not be yes. And I think it's important that you think about it on the front end to make sure that you get what's best for your small business. Two different types of patents, utility and design. I'm not going to go into detail on this other than to say Utility patents are what we all primarily think of when we say patents. So it covers the utilitarian aspects of an invention, how it works, how it operates, how it's put together. It doesn't cover the ornamental appearance. The ornamental appearance would be covered by a design patent. So Nike's, Cole Haans of the world have lots of design patents on different shoes. Apple's got design patents on GUIs for their phones. But they also have utility patents. So you can have a utility and a design patent on a product as well. Design patents typically run cheaper than utility patents, but their scope of protection is just fundamentally different. It's only protecting somebody from essentially copying your design. If somebody else can alter the design and yet get to the same end result, your design patent's not going to be worth a whole lot. They're just going to design around it really easily. So that kind of buckets patents. Then we're going to move to copyrights. Copyrights is the next form of intellectual property. Again, constitutionally protected. I also like Mark Twain quotes. I tend to read a lot. So Mark Twain, I like to put his quotes up here. It always is fascinating me that Mark Twain as an author seems to have more respect for the patent regime than for the copyright regime, because he would have probably been playing in copyright space a lot more. Maybe he felt like he got burnt. So his comments about copyrights are generally a little more negative than his comments about patents. So what is a copyright? It's an original work of authorship fixed in a tangible medium of expression. The rights are created automatically. So patents, never going to trip, stumble, and fall into a patent, right? Because you probably don't have enough money in your pocket for it to just fill out on the road for an attorney to appear and say, I'll take care of this. But for copyrights, you certainly can trip, stumble, and fall into a copyright, because the second you fix it in a tangible medium of expression, you get copyright protection in it. But it's kind of like a shark without teeth, because you can't actually ever sue somebody for copyright infringement, because the current laws in the United States require you to first have a registration. But notice the terminology difference. A patent is issued by the United States Patent and Trademark Office. A copyright is registered with the Copyright Office. Registered means it's already in existence, and we're just making a notation inside of our database, essentially, that there is a copyright here. So the Copyright Office doesn't give you the rights, if you will. They're automatically affixed, but because of the way our laws played out about suing for patent or for copyright infringement, you really do need to register that if you ever want to use your copyright in any format. So paintings, books, photos, source code, all of those things are going to be protected by copyright law. Copyright, we always say copyright is like a bundle of sticks. What do we mean by that? You get all these exclusive rights. You get the right to copy, the right to distribute, the right to display, perform, make derivative works. One important distinction between copyrights and patents, another distinction, is that copyrights are positive and negative rights. I get the right to copy, and I get the right to prevent others from copying. Remember, patents are only negative rights. I only get the right to stop others from making something. I don't necessarily get the right to make it. So copyrights in that sense can be stronger protection in certain instances, but obviously they cover different types of things. So positive and negative right versus just on a patent is only a negative right. We'll go to trademark law next. Trademark law, this slide is not as good when there's not interaction among the group. But anyway, when everyone's in the room, I put this slide up like so many times, and nobody's been able to tell me, except for people who've heard me talk about this before, and then they get the punchline already. But nobody's been able to tell me why this is a funny trademark. The fact that the Kraft Group LLC federally registered for the 19&0 mark for pre-recorded DVDs, all featuring sports. And the reason that's funny is because the Kraft Group, obviously Robert Kraft, owns the New England Patriots, and that was the year that the New England Patriots went 18-1 in the entire United States celebrated except for New England, because nobody liked that era of New England Patriots because it was Tom Brady, who was, winning Super Bowls left and right. This was the great catch where David Tyree caught Eli Manning's pass off of his helmet. They lost to the Giants. So 18-1, not 19-0, which is why this trademark is funny, that they registered this, because they were going to use the trademark to celebrate the first undefeated season since the Miami Dolphins did it previously. So anyway, that's a complete tangent, but it helps illustrate trademark law a little bit, and then it can be humorous. What is a trademark? Anything that acts as a source identifier can be a trademark. It can be a design mark, it can be a word mark, it can be a sound, it can be a smell. Literally, it can be we already said sound. It can be anything that can act as a source identifier. And the illustration I always give on this is when I stand up here and I go ba-da-ba-ba-ba, everyone knows exactly what company I'm talking about. Meaning that jingle could be, and I don't know if it is, I assume it is, trademarked by McDonald's because it's what identifies them. If you hear that, you think McDonald's, you think Big Mac. I like the double cheeseburger because you get the 2 for $3 deal, but I think it's a little more expensive now. But anyway, why do we have trademark law? We have trademark law to prevent consumer confusion. So trademark is meant to protect us as the consumer. What we're trying to do is make sure that when you go into Dillon's or Walmart or Target or your store of choice, 7-Eleven, and you buy a Coke, when you open the Coke and drink the Coke, you know exactly what it's going to taste like before you put your lips to the bottle. Because I've already had a Coke, it was labeled the exact same way, and therefore I as a consumer am not going to be confused. If you took a drink of the Coke, what was labeled Coke, looks like Coke, and it tastes like Mountain Dew, you're going to have a problem. We're going to have multiple problems. So we don't want that to happen. We want consumers to be protected. We don't want the old bait and switch to be pulled on our consumers in the United States, which is why we have trademark law to prevent consumer confusion. A side benefit, this is completely like an argument in the legal world that we all lose our minds over. A side benefit is it enables companies to build brand equity and brand identity. Some people will argue that that is a part of the purpose of trademark law is to be able to do that, not just a side effect. I strongly believe it's just a side effect. The real purpose is to prevent consumer confusion. That's a little bit of a nuance. So trademarks, you can trip and stumble into a trademark just like you can a copyright a little bit, because you do not have to register your trademark. Notice again, registration versus issuing. When I go to the United States Trademark Office and I say, hey, I'm using this mark in commerce, I'd like to get a federally registered trademark on it. They do not issue me a trademark, they register the trademark because the trademark is already being used in commerce prior to me filing for the trademark registration. Now, there is something called an intent to use application. It's outside the scope of this. It's basically where you can, if you have a bona fide intent to use the mark within a certain amount of time, that we can pre-register it ahead of the actual use in commerce. The rights technically don't attach until you use it in commerce, all these legal nuances stuff. But at the end of the day, trademarks have to be used. We don't want people warehousing trademarks. So if you're not using it, you're going to lose it when it comes to trademark law. So we have a question in the room. Yes.
If another business buys another business, what happens to the businesses being bought out as trademarks? Like, do they acquire them or do they retain them or how do they actually transfer?
Yeah, that's a good question. The question was, I'm a small business and another small business comes and buys out my small business. And I had trademarks. Does the new small business, the acquirer, get my trademarks? And the answer is yes, so long as it's properly documented. You would do it through an assignment. You would need to assign the goodwill associated with the trademarks. You can't just assign the marks. You got to assign the goodwill, meaning the marks have to be used in a fairly consistent manner with how the original business was using them. All of that has to be done. If not done correctly, it's this crazy term called naked licensing. Nowhere near as like sexual as it sounds. It just means that you've licensed it, you've moved it without the goodwill being associated with it. So it's naked licensing. We don't like naked licensing. We don't allow naked licensing. And we also don't like assignments and gross. So basically the two of them, I slightly mixed that up. I should clarify. Naked licensing is when I still retain ownership of it, but I'm letting someone else use it, but I don't have the proper quality control checks in to make sure that it's being used in a manner consistent with how I'm using it. That would be naked licensing. Assignment and gross just means I assign it without assigning the goodwill. But yes, you can definitely all intellectual property can be moved from company to company to company, just like an asset. So it is an asset of the small business. A good question. So common law versus federal law. The reason I throw this up here is two things. I like to highlight one small city in Illinois, and then I also like to draw a distinction between the little TM and the circle R. So for anybody who's ever seen a circle R after a word, which I'm hoping is everybody on the call, and if not, go to Walmart tonight and stare at all the different things and become an IP nerd like me, and you will see a lot of circle Rs. What does that circle R mean? It means it's federally registered. That trademark has been federally registered with the United States Trademark Office. So circle R is retained for federal registrations only. If I'm relying on common law rights, meaning I haven't federally registered it, but I am using a mark in commerce as a source identifier, I put a little TM afterwards. So that'd be trademark protection, but it's not federally registered, so I don't have the circle R. So certainly, once you start to notice this, you'll see a lot of TMs versus circle Rs. There's a lot of strategy that can go behind that and why I might want to put a TM, why I might not want to put a TM. But the story goes, there was a place, I have no idea how I'm doing on time. Rob, how am I doing?
You're great.
Okay, so the story goes that there is a small city called Mattoon, Illinois. I always ask this question too, and so far nobody has been to Mattoon, Illinois, but I'm hoping someday someone. So if anybody online has been to Mattoon, Illinois, please put that into the chat because I need to know that for just my own personal edification. But Mattoon, Illinois had a restaurant, a ma and pa shop restaurant called Burger King, but it was not affiliated with the national conglomerate Burger King that we all think of. And so when Burger King started to be, when the King, like the Whopper Burger King, started to become a big thing, they wanted to go into Mattoon, Illinois and put a Burger King up, but the mom and pop shop said, no, you can't do that. I have common law trademark rights in Mattoon, Illinois, because I've been using the term Burger King for years on end. We have milkshakes. Supposedly they're good. I haven't had them yet, but they also sell burgers and all these other things. Clear overlap. The conglomerate Burger King with the King holding the Whopper is going to be playing in the exact same space as the mom and pop shop Burger King. And so it doesn't take long for us to figure out that consumers are going to be very confused. You may be walking into one thinking I'm going to go get a Whopper, and I get in there and they don't even have Whoppers because it's the mom and pop Burger King. We won't like that. So what happened was in Mattoon, Illinois, and a geographic zone surrounding it, you will not find a national conglomerate Burger King because of the mom and pop place. I don't know. That was a number of years ago that I looked into all this. I'm assuming it's still the case. I do know when I looked into it, they were offered a lot of money to basically sell out their business and their name. They chose not to do so. They really wanted to stick with the goodwill that they have already built. So what is a trademark protection? It's a positive and a negative right, just like copyrights. So patents are only negative rights. Copyrights are positive and negative. The right to do something, the right to prevent someone from doing something. Trademarks are positive and negative. I get the right to use the trademark, and I get the right to tell other people not to use the trademark. So positive and negative, I keep emphasizing that because I think it's really important for you to understand what rights you're actually getting when you go out and get these different forms of intellectual property. Okay, that brings us to trade secrets. Secret ingredients, that's the secret. That was a Coca-Cola advertisement. Coca-Cola obviously is still held up as the most revered form of a trade secret. Supposedly there's a vault. It has the exact way of the amount of chemicals that went into all of this, how it was mixed, how long, what it tastes like. So trade secrets are anything that's information that can be kept secret, so not generally known to the public. And because I can keep a secret, I get a benefit out of it. That's a trade secret. So it can be chemical formulas, it could be recipes, manufacturing sequences. We talked about mold designs, tech spec packages, all different kinds of things can be trade secrets. It's important to realize that trade secrets only prevent someone from improperly taking the trade secret. If someone independently creates what you have called your trade secret, I don't care. That's called competition. So if you want to rely on trade secret law, realize that you're only relying on somebody improperly stealing your trade secret. If they independently create it, independently invent it, then you can't stop them. Now, if you have a patent, you could potentially stop them. And this is where in certain areas, chemical formula are one of them, there are companies that go back and forth. Should I file a patent? If I file a patent, I get stronger protection during the period of time in which my patent is valid. However, I have to disclose information in the patent that the general public will then know once my patent expires, which is typically 20 years after the earliest filing date. Or do I want to rely on trade secrets? And I could potentially keep this thing a trade secret for 100 years on end. The question is, can somebody easily reverse engineer it? If they can easily reverse engineer it, then trade secrets is not a good idea, right? Because they're going to easily reverse engineer it. Not a lot of money is going to go into it. If it's a pain in the butt to reverse engineer it, and you don't think anybody's going to be able to do it quite to the quality of which you've done it, then trade secret law may make sense. That's one of those areas strategically, as a small business, you'd want to think through what is the best route for me. Putting it all together. Oh, do we have a question? So copyright law, the length of copyright protection has evolved and changed several times throughout history. I think right now it's the life of the author, so life of whoever made it, plus X number of years. I'm going to say 70, don't hold me to that, after they die. It's kind of morbid, but so there is, and obviously for businesses, there's different variations of how long that would be in that instance. But yeah, copyright law is one area that we've evolved and how long the copyright protection should last. There's a lot of like blog sites, again, for IP nerds. You can go out and like see what's coming off copyright next year, and it's all exciting. And we go, that's why Winnie the Pooh came off recently. And there was that whole Pooh and it was a horror movie with Winnie the Pooh that came out. I heard it was terrible. I didn't watch it, but I just heard it wasn't good. But anyway, good question though. Yes, copyright protection.
So after it expires though, can you not, is there no way for a business to be like, no, I'm gonna keep it? Cause like, say example, Disney, like obviously those films last a really long time.
Yeah, so great question. The question is once a copyright expires, is there anything a small business could do to claw back some element of protection? And the answer is probably not in copyright world, but you can get really smart and creative with how you evolve things and by putting all of them together. So let's say I'm Walt Disney. It would have been awesome, but I'm not. But let's pretend I'm Walt Disney and I created Mickey Mouse one day on a piece of paper and I go, my gosh, this is brilliant. And so I have copyright protection. I go register with the Copyright Office. It's original work of authorship. It's fixed in the tangible meaning of expression and has some element of creativity to it. Therefore, I get a copyright in it. But I also say, you know what? I'm going to start making movies with this dude on it. And I'm also going to start making shirts. So I'm going to get a trademark too. So trademark protection is different than copyright protection, right? Copyright protects somebody from copying it. Trademark protects somebody from confusing consumers as to who the source of the article is. So trademark protection lasts indefinitely. As long as I'm still using it and consumers still affiliated with me, I get trademark protection. So maybe I lose my copyright protection. Let's say it's the full term of the copyright, it's done, but I'm still using it in commerce. I could still have trademark rights. So I can't claw back my copyright rights, but I can get some element of protection through trademarks. If you really want to, well, you can also do some design patent stuff in there if you really want to get creative. Okay. Elon Musk quote about it's like baking a cake. So, okay, I don't know how I'm doing on time. Do I have a few minutes yet? Great. So last night, I'm not making this up. Last night, I stayed up to like 1 a.m. because I got fixated on Ray-Ban glasses because I wanted to do an example. Someone in the office here had pointed out that Ray-Bans go back to military. And I'm like, I didn't even know that. And I used to have some black Ray-Bans. Plastic frames, they slid down on my nose, didn't like them, so I got rid of them. But I got fixated by Ray-Ban glasses, and I mean, I went down a rabbit hole. So Ray-Bans, you know, the brand started to be used in the late 20s and 30s. It kind of came out because there were these things we called aviators, which that's what we used to call pilots back in the day, aviators. They were flying, and they got the sun in their eyes, and we were getting more and more into flying, World War I, World War II. And so this company, Bosch and Lomb, I believe I'm pronouncing that correctly, I may not be, they actually came up with Ray-Ban. And so my purpose of this, other than to tell I went down a deep, dark rabbit hole, my purpose of this is to show you how using Ray-Bans, I can weave all forms of intellectual property together to try to help illustrate the different regimes and how they all interact with one another. So this picture right here is a pair of Ray-Ban glasses that you used to be able, can't buy them anymore. I did not buy them. They were very expensive. From 1944. This is a 1944 pair of Ray-Ban glasses. So then I start looking and I go down this hole and I really wanted to find the original patent associated with Ray-Bans. You read some stuff on Wikipedia, it starts throwing out some dates. I did as much searching as I could. Nothing had the original patent on it. So I believe these three patents are likely closely corresponded to the original patents of the Ray-Bans. They're all owned by Bosch and Lomb. Obviously, they're all expired now because they're very old, but you can tell on the one on the most left side of the screen, that's the earliest one. The middle one is the next one. Those two were focusing on the lens designs themselves and how they might help reduce some glaring associated with it. And I think the middle one was about some trifocals and bifocals and all those things. So what they started with, and this was in the 30s, they're like, oh my gosh, like, this can help with the glare and everything. And so our aviators are better protected, which is good because World War I, World War II, we want our aviators to be protected. So they started selling this product. Bosch and Lomb started selling this product. The one on the right, the farmost right one, is the new coating they came up with that even helped with the glare a little bit further. That was in, I think, 1944. 1944 is when that patent was issued. That one on the far right corresponds most directly with this pair right here. See, if we go back and forth and you don't blink too much, you will see they look very similar, right? Okay. So my point being here is obviously Bosch and Lomb went out and got patents on the technology, on the design of the frame to help reduce with glare, on some scratch resistance, and then also on the new coating that can be put on top of them. So patent law, that's how the company said, I'm going to use patent law to help what I'm doing. Then in a different area like copyrights, they start taking pictures and photographs and putting together advertisements all about the Ray-Bans. And so I really love the fact that they emphasize and they closely talk about how flyers wear Ray-Ban. This has been really relevant in the 40s, something that would have resonated with the consumer base. So here are some advertisements. Now, we can get really tricky on this. Who owns the copyright? Maybe not the company, maybe the advertising agency that put together retained the copyright rights. I don't know. The point here is to show that the next way that intellectual property can come into play was through copyrights, because they start putting out these different advertisements talking about the Ray-Bans and how they are good for air service standards and that pilots like to wear them. So again, the whole thread through. Ray-Bans there, 1944, actual pair, all the way on the right, looks very similar to that actual pair, which the patent issued in 1944, meaning it was filed a few years before that. Oh, it was filed in 1944. I don't remember what year that one is. Well, 46 is when it issued. Okay. So yeah, it was filed in 1944. So it kind of lines up with the fact that these are 1944. And then if you look at the one that's in the middle there at the very bottom, the glasses again look very similar, Ray-Bans. So copyright law is how this comes into play. And then obviously genuine since 1937, you have Ray-Ban, they get it federally registered, they put the circle R after it. So they're using it as a source identifier. So now I've got trademark law mixed into this. So I've got patents on the invention themselves. I've got copyrights on my advertisings. I've got trademarks on the name because people are starting to use this as a source identifier. And then you have trade secrets because they're somehow manufacturing these. They're using certain materials. They're using certain blends. And they also have certain supply chains set up. So that's all proprietary information that they're going to keep secret. They're not going to give that to a competitor, because if a competitor got that information through a legal means, or not improper, got it through a legal means, then all that competitor would have to do is change the name, change the advertisements, and wait for these to come off patent, and they can very easily replicate exactly what Ray-Ban was doing. So it behooves Ray-Ban, Bosch and Lomb actually at the time, because Ray-Ban is just a brand, it behooves them to keep these types of things secret because there's a certain quality associated with it, and they don't want someone else to easily replicate the quality. So wrapping that all together, that's how you can very easily see with one product, Ray-Bans. I like using this, especially in the context, like I said, I'm going to try to have a DoD focus. It did have a DoD purpose behind it. They started working in the 30s because the aviators didn't want to be blind while they were flying. It is a great dual use technology, as we can tell, because we still wear Ray-Bans a day, and I was never in the military, so dual use technology, average civilians using it as well as military potentially. Just a great example of all the different forms of intellectual property and how they all come together. Oh, is that the last slide? Okay, I hit the wrong button. IP strategy scorecard. Sorry, we're almost done, I promise. Anyone has questions, feel free to interrupt. So when it comes to intellectual property strategy, I really harp on having a strategy. Yes, in the room.
So really quick before you move on to this slide on the Ray-Ban
Yes.
discussion. So if there are competing companies that make similar sunglass designs to Ray-Ban, which there are aviators and then your general like black design. So I guess in this day and age, and for example, the patent that you displayed that is now expired.
Yes.
I, as a competitor, just go and make that same exact design and start selling it, or how does that dynamic work with all these other companies with all these similar designs now, and how does that work with the patents and protecting that?
Yeah, so good question. The question, just to repeat it real quick, because I don't know how online people could hear it. The question is, obviously today patents expired. Can another company come out and start to just make a competing product so long as they're not infringing the patents in essence? And the answer is yes. Now, there is an element of potentially trade dress protection, which would fall underneath trademark law. Certainly Ray-Ban didn't seem to try to assert that I was able to find in my rabbit hole last night. But again, it was only one night. Maybe we could have found it if we looked harder. So there could have been trade dress protection, which means that would also go in indefinite. So trade dress is basically, as a consumer, I come to recognize something by the way it looks, and I recognize its source. But likely trade dress wouldn't even be able to occur here because it's a functional element. We don't allow trade dress protection for functional elements because functionality should fall under the regime of patents, not trademarks. And so if you want to protect the way something functions, go to the patent world, get out of the trademark world. But yeah, basically that's why when you go to the store now, you can find different knockoffs of different types of aviators and all of that, because it's out there for anyone to be able to do now. There are limitations. They can't use the word Ray-Ban on it because that would be violating their trademark, and their trademark is still ongoing because they're still actively using it in commerce. This was actually sold to some luxury brand not so long ago. Ray-Bans was, so it's no longer owned by Bosch and Lomb. Okay, so IP strategy scorecard. I talk about IP strategy a lot because as a small business, you got to figure out how you're going to use intellectual property to behoove your business and move it forward, not just for the sake of getting intellectual property. And so like, here is a quick scorecard that I threw together one time. So duration, how long do I want this intellectual property to last? If I want it to last for an indefinite period of time, like in my head, I'm like, I want this to last indefinitely, then obviously patents aren't going to be the right route to go because patents have a natural expiration after a certain period of time, but I'd rather go with trade secrets. So if I go with trade secrets, but then I come to find out, oh, it's easy to reverse engineer this. Well, so is trade secret really your best protection? So you got to start layering all these different things. Do I want to spend a lot of money? Do I not want to spend a lot of money? Is it a loss leader? Or am I trying to make money off this product? Am I trying to build a defensive moat? So if somebody comes and sues me, I've got 100 patents I can turn around and sue them on. That's going to be very costly litigation. Attorneys celebrate, no one else does. So you got to realize what you're really trying to get out of your intellectual property. And build your strategy around that. Don't just do it in a vacuum. So you should reevaluate your IP strategy for your small business on a regular basis, say every 6 to 12 months potentially. Obviously, if you're in an industry that moves very quickly, CPG, you may evaluate it more quickly than in an industry like building planes, which just kind of has tends to have a longer life cycle with each product line because of how expensive it is from an engineering standpoint. So IP strategy scorecard, just a quick example. I threw this last slide in here a little bit about contract callouts. Realize that if you take federal dollars, so if you take money from the federal government to develop a technology or to work on a technology, it's going to come with clauses relating to intellectual property ownership. You should not immediately repel backwards and say, oh my gosh, I just thought they were giving me free money. That's not how it works, right? The government's going to give you the money, but they want something in exchange. Now, there are awards where they may just give the money, but those are typically unique award situations. If you're entering into a federal contract and you fall underneath a FAR or a DFAR clause, there's likely going to be intellectual property involved, especially if R&D is involved. Same if you're a small business and you're applying for SBIRs, STTRs, they're going to have intellectual property clauses involved in that. That may be guided by uniform guidance versus FAR, DFAR, it all depends. But realize that when you take federal dollars, they will likely come with clauses relating to IP ownership. You should understand as a small business what those clauses mean. They're not necessarily bad, especially if you need the money, but it's important to understand what exactly you're giving up. So just realize that you need to go through that and understand what it means. In a lot of areas, you can't push back too much from some of those. It's statutorily required, it's regulations required. So if you want to take that pot of money, then you're going to have to abide by the IP ownership clauses. Two main areas of concern that you will see in contracts, specifically around federal dollars, is inventions and data rights. So I think that these sometimes get lumped together, sometimes they're kept separate, but inventions, again, we're going to be in patent world, data rights were more in copyright, software maybe, also like data results and other things like that, so proprietary information. You may want to fill out, like in some contracts, you'll have to fill out pre-existing data that you've already had prior to going into the agreement. That kind of goes into this last bullet point of, it's called a data assertion table. That goes into this last bullet point of understand the difference between forward IP and background IP. If I'm taking dollars and I'm making new stuff out of the dollars, that's likely going to be deemed forward IP. But it may involve elements of my background IP as well. So a great example of this is I've already got some software program written up independent of federal dollars. I take federal dollars to do a specific analysis using my background IP on CAD models that are provided to me by the government. So that analysis is going to create forward IP that is different than your background IP. It's the results. The government doesn't necessarily get to reach in and grab your background IP, but you are going to have to give certain rights to the forward IP most likely. Now, if they can't use those rights because the background IP is separate and distinct, then it kind of, that's where it gets clever for you to think through contractually, what am I trying to achieve out of taking these federal dollars in this instance? So I don't want to go into any more detail there other than to say, especially with small businesses trying to do SBIR, STTR, other types of federal awards, it's important to understand that the contracts are important. You should understand what they mean and how they affect your intellectual property. Okay. Any other questions, concerns, criticisms? Anybody online have any questions? Feel free to unmute. I think we'll be able to hear you right away. Otherwise, we have another question in the room. So, yes.
So if I'm developing a technology, let's just say it's a hobby that I'm doing, and maybe I have told some people about it, but now that I find that this technology might be useful for DoD, how do I go about filing for that kind of, if I did already disclose it to some people, or how important is that discretion, and what are the boundaries of that when developing a technology or realizing that I have a good idea to protect?
Yeah. So the question is specifically around, it's an invention that you potentially already disclosed publicly. And the question is can I still do something to protect that in the patent world, especially if now I've had the government express some interest in getting their hands on it? The answer is, as long as you're within a certain time period in the United States, you could potentially still get some patent protection. So the US has a modified first to file system. So we do have a grace period. Your own disclosure or offer for sale or sale of an invention cannot be used against you as prior art for up to 1 year after once it occurs. So you have a 1 year grace period. But realize that only protects you against your own personal disclosure. It does not protect you against somebody independently deriving it and coming up with it and then seeking patent protection. If they get in front of you in line at the patent office, they're going to be able to be in front of you in line. The only way you can then try to come back in front of them is to show that their invention was not independently derived, but actually came from your disclosure. That's very hard to prove from just a practical standpoint, that person saw mine, therefore did theirs. So it's always best practice patent attorneys will often say it's best practice before you publicly disclose something. If you think it's very valuable, you should go ahead and seek a patent application at that point. Again, though, realize everybody plays the game differently. If you're a small business that has a bank account like Elon Musk, yeah, it may make sense to go file a patent application right away because you have a larger bank account. If you have a smaller bank account, it may not make sense to proactively go out and spend all that money on something that doesn't eventually mature into a commercializable product. It's not necessarily fair or equal. Like, you have to play the game differently depending upon what your business is and depending upon how much money you have to be able to move forward. If you spend all of it on IP, you're never going to be able to release a product or service because you don't have any money to pay your employees or anything else. So there is, for small businesses in particular, there are times that you will forego seeking patent protection potentially because economically you couldn't justify it or make it make sense. Awesome. Well, I think that we're going to go ahead and close it out then. That covers through all the things. Certainly, if anybody has questions, feel free. I think our emails are out there based off of this. You could reach out to the MAC team or the FirePoint team. Anybody, if you have specific questions, happy to answer them. Otherwise, thank you very much for attending.